By the way, one of the things that's going to happen in coming months, you're starting to see the suits filed already. I think ultimately the Supreme Court is going to say part or all of what he's done is unconstitutional.
And most importantly, his impoundment of funds, which is both illegal and unconstitutional.
To hear the judge from the bench say that in his 40 years as a judge, he has never seen something so blatantly unconstitutional sets the tone for the seriousness of this effort.
Anyone who has paid any attention to recent events in the United States will undoubtedly have heard the term unconstitutional repeated frequently. The actions of President Trump during his first 100 days have been so chaotic and whiplash-inducing that real life is beginning to feel like a joke from a stand-up routine.
With all the terrible things going on in America right now, and you know exactly what I'm fucking talking about.
From an executive order calling for the end of birthright citizenship, to the illegal deportation of legal residents, to the arrest of a sitting judge, many of Donald Trump's actions have been called unconstitutional in the media. Federal judges have put roadblocks up in front of the current administration, including a unanimous decision from the Supreme Court. Controversially, many of the orders have been left unread in the style of Andrew Jackson. So with all this headache-inducing behavior in the background and foreground of public debate, I thought it would be a great time to take a look at our founding document and to see what it has to say about the powers and limitations of the American presidency. For those of us who are not constitutional scholars, our understanding of what the presidency does and is informed by popular culture, interpretation of the phraseology of the Constitution, and in many cases of unchallenged precedents. Today, we're going to take a look through each section of Article 2 in order to better understand the role of our nation's Chief Magistrate as envisioned by the Founding Fathers. Hello everyone, I'm the President's Guy, just a man with a fondness for history and reading, in particular of the American presidency. Before we get started, remember to like, share, and subscribe so you never miss a video. For the purposes of this exercise, we will be sticking to the part of the Constitution that deals with the requirements, restrictions, and authorities of the President. We will not be examining the election process, in part because a lot of that was rendered moot by the 12th Amendment, which we will discuss in brief. I also made a concerted effort to kind of ignore a lot of the language that, subsequent amendments have rendered obsolete. That way we're not just running around in circles. Supreme Court cases, we'll talk about those at the end because those tend to have the most numerous and recent effect in recent memory. And even just over the last 50 years. Now, before we get into Article 2, just a quick little shout out from Article 1, Section 9, Clause 8 of the Constitution, since this has come up recently with President Trump accepting a plane from the country of Qatar, and essentially states that anyone holding a government office is prohibited from accepting any present, emolument, office, or title from a prince, from a king, or any foreign state without congressional approval. So this, for example, would be the country accepts the Statue of Liberty from the nation of France, and Congress accepts that gift. It doesn't go to one person individually. Trump receiving a plane for his own personal use, for his own personal library, would in fact fly in the face of this clause. However, they're trying to spin it by suggesting that it's a present to the Department of Defense. But if it was to the Department of Defense, then the Trump Presidential Library wouldn't have access for him to have it to fly around to do whatever he wants. This would be different than the Air Force One plane in President Reagan's library, which was just his from his term in office and is just there on display. Starting with Section 1 of Article 2, this opening paragraph seems pretty simple on the face of it. The president's the head of the executive branch, which kind of is vested with the power of carrying out and enforcing all the laws that are created by the legislature. Although how the chief executives have kind of gone about that has varied greatly over time. The most controversial part of this opening paragraph is the use of the pronoun he. As we know, the Founding Fathers were, all men. And as a body, they never foresaw women holding political office. So does that mean that the Constitution bars them from doing so? Well, no, it doesn't. Throughout the years, there have been plenty of instances of case law where it's been interpreted for practical purposes that all the he's in the Constitution are gender neutral. This was made explicit by the 19th Amendment granting women the right to vote and to hold office. And while it hasn't happened yet, it's entirely possible and very likely that we will see a female president at some point in the future. Skipping down to the requirements section, this clause states essentially you must be a citizen at your birth of the United States. And the qualifications of this are wide-reaching, and there's a Supreme Court case pending right now on birthright citizenship, and the results of that, we'll see how that goes. The later portion of that was applicable to the people at the time, because most, if not all, the founding fathers weren't even born here. They were born primarily in England or in France, and it would set the earliest year of birth for someone who wasn't born here to be 1773. Some kind of wonky examples of this that haven't exactly been tested yet is like Ted Cruz, for example, who is born in Canada to Cuban parents, but who were U.S. citizens. So does that exclude him from running for president? He didn't get very far in the 2016 cycle, so it's kind of hard to say. But those are some of the examples where the limits have not really been tested fully as to what that exactly means. And you could imagine this Supreme Court case coming is probably going to talk about that. Now, this clause has been an area of intense debate for decades, and it describes what happens in the event that the president dies or is thus unable to perform the duties of office. Now, on the surface level, our modern understanding would indicate that in the event the president is indisposed, either in the event that they're removed from office, they die, or they're temporarily incapacitated, then the vice president becomes the president. The issue with this is that it wasn't until the death of William Henry Harrison, who was the 9th president, and Vice President John Tyler takes over, that this clause even had to be put into effect. John Tyler essentially declared himself to be the president, and there wasn't a whole lot of pushback per se, because what we didn't understand was, is the president merely acting in the role, or are they not? This became known as the Tyler precedent, and it went unchallenged literally until the 1970s, when the 25th Amendment is passed, conveniently in time for the Ford and Nixon and Agnew fiasco that was going on, and it established the procedures for official succession for the presidency. Who's next in line, after that, because what had happened up until that point is when the vice president would take over, the vacancy of the vice presidency wouldn't be filled. So you have multiple presidents, Andrew Johnson, Chester Arthur, who just never have a vice president. And what would have happened in the event that they died as well? We see it with Nixon and Ford in the 1970s. Spiro Agnew, who was Nixon's vice president, resigns. His position gets filled by Gerald Ford, who then takes over as president when Nixon resigns. Now, luckily, we had the official capacity to do that with the 25th Amendment, but before that, it wasn't entirely clear what was actually going on. Now, this clause is pretty straightforward. Simply put, the president during their term cannot receive a pay cut or raise, and any alterations that they get would not take effect until the next president takes office, or until the next term. This actually happened during Grant's administration in what was known as the salary grab scandal, and Congress passed an increase for themselves that would take effect when the next Congress took over, which would have been 1872. But they also gave themselves a provision which would have given them basically a full year's salary retroactively. So for the previous Congress, they went from $5,000 to $7,500 a year in pay, but they wanted to give themselves back pay, essentially. And this was quickly repealed. There was tons of public backlash, but the president and Supreme Court justices also got a doubling in their pay. So Grant went from $25,000 to $50,000 from his first to second term. And it was pretty controversial that he signed the bill, because at that point the country was involved in a huge financial panic. It was such a big scandal that Congress didn't even attempt to give itself a raise for decades after that. It wasn't until the 20th century that you even see Congress try to give themselves a raise again. And at this point in time, it's so unpopular for them to do that you don't see it all that often. Now, in terms of the presidential oath, what is actually surprising for a lot of people is that there are parts of the oath that we do now that isn't actually constitutionally required. There's nothing in the Constitution that says you have to place your hand on a Bible. In fact, President Trump, during his second swearing in, did not place his hand on the Bible that Melania was holding for him. There's also nothing in the Constitution that says you have to say, "So help me God." And many presidents have implemented this oath with varying degrees of success. Now, getting down to Section 2 of Article 2, this is where we get into the actual specifics of the duties and powers of the president. Now, this statement is powerful for a number of reasons. It places the president in charge not just of the federal military, but also specifically gives them authority over state-level militias, such as the National Guard units. The president is the commander-in-chief for all military, whether they're state or federal. Now, this refers to the president's cabinet, which over the centuries has changed in its specific nature. For example, instead of a Secretary of War like we had around the time of the Civil War, we now have Secretaries of Defense and of the respective military branches such as the Army and Navy. This allows for the president to have, at least on paper, qualified department heads that come to the president with ideally excellent information and allows them to make the best decision. This essentially frees up the president in a sense because it allows them to delegate tasks, and really, on paper at least, if something comes before the president, it's an incredibly important decision. It also gives the president the power to commute and pardon people for federal offenses, so they can't pardon people for state-level offenses. The subject of wide-ranging controversy, especially after the pardons you saw at the end of Biden's term and at the beginning of Trump's second term. Foreign policy is such an underrated and up until recently kind of overlooked part of the president's duty. The passage is often overlooked because the power is seldomly utilized by the president. On the surface, it simply outlines the process of diplomacy and filling cabinet positions or judicial vacancies, and it makes it clear that they require Senate approval. It also gives the president or the heads of the departments the ability to name subordinates, which, now that we live in a day, even after Trump and all the Doge stuff, there are hundreds of thousands of people that work in the federal government, in the bureaucracy, and all that. It makes the system, in theory, more efficient by, again, giving the ability to delegate. The overlooked part of this passage is that treaties it outlines, which are negotiated by the president and confirmed by 2/3 of the Senate, automatically have the force of law. That means that if the president had a friendly Senate, for example, they could use diplomacy feasibly to cut the House of Representatives out of the legislative process entirely. Now, the power has rarely been used so cynically, and because more often than not, the Senate is not in a 2/3 majority for the president, but on paper, this could be something along the lines of, like during the Civil War, when the majority of both houses of Congress were Republican because the southern legislatures had been removed due to secession. So it's one of those things where you could essentially cut an entire House of Congress out of the process. But given how partisan we are these days, I wouldn't expect to see something like that. Now, this bit is really, really kind of sketchy. It's the recess appointment clause. Now this is an often unused privilege, but one that could really be abused if they had to, and Trump has kind of hinted at this in his first and second terms. Since the Senate has to approve certain cabinet positions like your Secretary of State, Secretary of the Navy, Health and Human Services, all that kind of thing, and depending on how friendly they are with the president, and such as right now and even during Biden's term where it's basically been 50-50, if the Senate's controlled by the opposition party, it can be very difficult for the president to get through certain nominees, especially ones of a more questionable nature. You saw this, Mitch McConnell and a few Republicans going against Trump during certain cabinet appointment sessions. So what could happen is the president could fire and rehire cabinet positions while Congress is out of session, and they would just be in that position until Congress came back in, at which point they could either, confirm or fire the appointee. But depending on, when you do this, if it's right after Congress goes out of session, you could have someone in these jobs for months at a time. And it's kind of a big loophole in the Constitution in terms of kind of abusing power, but it's there. Heading on down to Section 3, we start off with the clause about the State of the Union. Now, as we know it today, the State of the Union is a major policy speech, and it kind of dominates national news cycles, and it anchors our political calendar. However, its origin was originally as kind of a general check-in with the president to Congress, and it would include basic, legislative ideas for the coming year, but it certainly wasn't kind of the spectacle that we see it to be today. And up until the 20th century, the president didn't even give the address in person. It would be written as a letter, the president would choose an officer, and they would read it to Congress. Woodrow Wilson was the first modern president to break this tradition and give the State of the Union in person, but ever since Herbert Hoover, every subsequent president has given the speech in person. This passage also gives the president the ability to call and to adjourn special sessions of Congress, although the latter rarely, if ever, happens. And it designates the president as the person responsible for faithful execution of the laws. Perhaps the most controversial part of Article 2 is the impeachment clause. Now, in the history of the United States, we've had 45 people, 47 presidents, but Cleveland and Trump did it twice, that have been the president. And we've only had 4 impeachments, 3 of which happening in the span of 25 years. The first one coming with Andrew Johnson violating what would later be determined unconstitutional in the Tenure of Office Act, which stated that the president needed Senate approval to fire cabinet appointees. The next would, of course, be the most well-known, which would be the Monica Lewinsky scandal involving President Bill Clinton, where he was caught lying to Congress. And then you see it twice impeached with Donald Trump. Now, hopefully, and I'm afraid this might happen, this is probably going to be kind of a more frequent thing we see. And I'm predicting now that if the House flips in the midterms, you will see an impeachment of Donald Trump again. Hopefully this doesn't become a partisan weapon used by Congress, but I'm afraid that it will be. During Biden's term, we saw a lot of inquiries being floated around about, are they doing impeachment inquiries? And it's just not productive, and it's not good, especially the second time around with Trump, where it was blatantly obvious that nothing was going to happen, and it was 2 weeks before he was leaving office anyway, and it just makes the other party just look petty and bad. Trump's first impeachment, of course, coming with the alleged collusion with Russia, and the second with the inciting the riot of January 6th. Now, we've never had an impeachment process end with the removal of office. Andrew Johnson was one vote away from being removed, but the reason for this is kind of twofold. First is partisanship, of course. You have people who are just blindly loyal to the president if they're of the same party. Feelings on that will vary widely depending on your policy stance. But the second one is confusion. In the case of Trump, high crimes and misdemeanors and treason are not really all that defined in the Constitution. Treason is very narrowly defined as levying war against the United States or adhering to their enemies, giving them aid and comfort. The problem is, particularly in the case of the Civil War, Robert E. Lee was tried for treason, but it was kind of excused because in order to try Robert E. Lee for treason, siding with the enemies of the United States, you'd have to acknowledge the Confederacy as a country, which it wasn't. So it's a whole big complicated mess. High crimes and misdemeanors are also not really defined all that well. All the Supreme Court cases we've had and all the time since the Constitution was ratified, that's never really been determined as to what those are. It's kind of just up to Congress's interpretation. And because it's up to interpretation, most of the time, or 100% of the time, we've just had acquittals because it's, up to the individual thought process as to what qualifies as a crime. So it's very unlikely we will ever see a successful impeachment. Given the rumors and just outright statements by many of President Trump's supporters, including Steve Bannon.
President Trump didn't bring up running for a third term. Myself and others brought up running for a third term. President Trump is going to run for a third term, and President Trump is going to be elected again on the afternoon of January 20th of 2029. He's going to be President of the United States.
The idea of a third presidential term has been thrown around quite a bit in regards to Donald Trump, and in response you've seen memes about Obama being allowed to run for a third term, and House members have introduced laws and amendments calling for this, but specifically limiting it to re-election of a non-consecutive president, which would allow Trump in but not anyone else. So I figured it would be kind of prudent to take a look at the constitutional amendments dealing with the presidency. As mentioned, the 12th Amendment makes clear that a person who is not eligible to be president cannot be the vice president, as they are next in line to the presidency. So this would rule out Donald Trump running as J.D. Vance's presidential candidate, because when you're in the office of vice president, you're the next in line, and you have to be ready to take that position. And if you've already held and we'll get down to this later, the constitutional cap on elections and sitting as president, then you are not allowed to be the vice president. For example, Gerald Ford, who had less than one full term as president because he took over for Nixon and then was not subsequently reelected, was floated around to be the candidate for vice president for Ronald Reagan in 1980. He could have constitutionally done this, and then if something had happened to Reagan, he would have been able to take over. The 20th Amendment made many changes to the presidency, and it filled in a lot of gaps. Simply put, Section 1 states that the president and the vice president's term shall end at noon on the 20th day of January. All this did was move the inauguration date up about 6 weeks from its original place around March 4th. Section 3 takes care of, an often ignored potential that likely will happen at some point in the future, and that is what happens if between the election and the inauguration, the vice president-elect and or the vice president-elect were to die. If the president-elect were to die before the inauguration, then the vice president-elect would then serve as the president. In the event that they're both displaced, then Congress would then select who the president would be. Section 4 simply just lays out which House of Congress is selecting which member of the ticket to be filled. in which case the House of Representatives picks the president and the Senate picks the vice president. Now, the 22nd Amendment has been talked about a whole lot lately because the idea of Trump serving a third term has come up. Now, this amendment I feel is particularly important to read the text verbatim. No person shall be elected to the office of the president more than twice, and no person who has held the office of president or acted as president for more than 2 years of a term to which some other person was elected president shall be elected to the office of president more than once. There's also a stipulation there that this amendment would not apply to the sitting president at the time, who was Harry Truman, who in theory could have run for more than 2 terms. This is important for a variety of reasons. It essentially stipulates that if when you're elected president, you get 2 terms or 10 years. So, for example, if you are the vice president and you take over after the death of your president, past the halfway point, you could finish out their term and then still be elected to 2 of your own. For example, Lyndon Johnson, who took over after JFK's assassination, did so past the 2-year mark of Kennedy's presidency. He was re-elected in 1964, and he could have been re-elected in 1968 had he chosen to run. He did not. A president, for example, like Gerald Ford, who took over after Nixon, would have filled the majority of Nixon's term. He could have been re-elected in 1976, but if he had been, would have served approximately 7 years, but he could not have then ran for another term because that would have put him over the 10-year mark. Now, what people will argue is that because the amendment says elected, then in theory someone could be appointed or assume the position of president in a very long, complicated way of, for example, Trump being elected to Congress and then being made the majority leader, and then the president and the vice president both stepping aside, which again is a scenario that is never going to happen because no one is that blindly loyal to where they reach the apex of political power and then they just hand it over. But many people will argue that that could happen. We haven't seen it really tested yet, and I guess we won't really see it tested unless Trump legitimately tries to run again in 2028. But I'm skeptical as to whether that's going to happen, because he will be 83 at that point. As mentioned before, the 25th Amendment deals with the issue of presidential succession, and it firmly puts into place the precedent established by John Tyler. It also kind of clears up some of the fuzziness in the chain of succession, which was a nuance when America was a kind of a young agrarian republic, but in the age of nuclear weapons and command and control, those gaps really had to be filled in. Section 1 merely states that when the vice president assumes the role of president, they are not acting in the position, they are the president of the United States. Section 2 provides for the procedure for filling a vacancy in the vice presidency, which oddly enough came at the time where Spiro Agnew had to be replaced by Gerald Ford, and Gerald Ford's position as vice president was filled by Rockefeller. Section 3 kind of talks about temporary instances of incapacitation, often in cases of anesthesia, or whatever is temporarily keeping the president from discharging their duties, in which case the vice president is acting as president. You saw this during President Biden's term when he was put under for a colonoscopy, and for those 2 hours or so, Kamala Harris was the acting president, but was not the president. Now on to Section 4. This very lengthily worded passage explains how the vice president and the cabinet would remove the president and how Congress would settle the dispute in the case that the president disputes their being removed. This clause has often been called to be used, most recently against Donald Trump, but has yet to ever actually be attempted, and I'm sure you see it all the time. Implementation of the 25th Amendment, you see it all the time in your social media, and in our era of intense partisan divide, you're probably going to keep seeing it for some time to come. But again, with that intense era of political divide, you're unlikely to actually see it be implemented, because it would require the president's cabinet and, a fair majority of Congress to go against the president, which is probably not going to happen. Now, as many people are probably aware, when issues can't be settled legislatively, they're settled judicially. This can either be kind of to answer many questions about the constitutional vagueness and language, or simply to stop a president from doing something. This principle, of course, rests on the idea that the executive will yield to these directives, and that if they don't, Congress will take punitive action, which lately has not been the case. There have been a number of Supreme Court decisions pertaining to the President of the United States, and they have ranged from minor administrative questions to those of outright immunity from liability and prosecution. Marbury versus Madison was a case in 1803, and it established the idea of judicial review, which is what we know now as the Supreme Court reviewing laws and determining things to be constitutional or unconstitutional, but to that point, that wasn't a thing. It also made distinguishments between appointment and commission powers of the president, and stated that the president might have to commission officers that they didn't want but were appointed by the heads of a department. So, for example, if the Secretary of State names someone in that department, then the president might just kind of have to accept it. About 35 years later, Kendall versus United States ruled that the president does not have the authority to order officials to do anything that contradicts their legal duty. Basically, if your job is this, the president cannot tell you to go against that or to commit a crime. Now, Myers versus United States was a case in 1926, which actually ruled on the Tenure of Office Act, which was the law used to impeach Andrew Johnson. The Tenure of Office Act was created on paper to protect the cabinet officials that Lincoln had put in place, basically from Andrew Johnson when he became president after the assassination. And it required the Senate approval to fire cabinet secretaries in the same way it requires Senate approval to hire them. This was done essentially knowing that Andrew Johnson would violate it and would give them full reason to impeach him. The law, even at the time, was deemed probably unconstitutional, but this case ruled that the president should and does have the unilateral authority to remove officials without the need for Senate approval, which is probably a good thing. In a similar vein, Humphrey's Executor versus United States defined that independent regulatory officers' duties were both legislative and judicial, and that allowed Congress to restrict the president's ability to remove them, since they weren't outright executive officials. This has kind of come up recently as Trump has fired a lot of inspectors generals in the early days of his second term, and Congress has kind of just chosen to do nothing about that. National Labor Relations Board versus Noel Cannon Company is one from 2014, and it ruled that recess appointments can only be made during recess periods between official sessions of Congress. They also held that any position can be filled in these periods, even if the vacancy of the position occurred outside of the recess window. Basically what that means is Congress can't be called into a special session and then called out of a special session just for the president to, make a recess appointment, which is probably a good thing. At the time in 2014, it was felt as kind of just an attack on Obama, but it's probably a fairly, reasonable ruling. Now, these next few cases more kind of directly impact the president's authority and whether or not they're liable in certain cases. Youngstown Sheet and Tube Company versus Sawyer was a case in 1952 during the Truman administration where there was kind of a threat for a steel strike, and in order to not, destroy the economy, President Truman tried to have the federal government kind of assume the operating capacity of these companies, and it was ruled that this is in fact unconstitutional and an overreach. And it's actually kind of a funny story. There was later a party after the ruling was issued. President Truman was at the house of one of the justices of the Supreme Court, and while they were talking, Truman said, I hate your ruling, but I love your drinks, which was kind of a magnanimous way for him to kind of accept the defeat he was handed and still be cordial with the Supreme Court justices. Train versus City of New York in 1975, it ruled that the president does not have the ability to freeze funds that Congress has allocated to be spent. A ruling that I'm sure will be brought up involving the Trump administration in the near future actually has been implemented a few times because they've attempted to freeze funds that Congress has already allocated, which, since Congress holds the power of the purse, so to speak, the president doesn't have the ability to block money they've already spent. Clinton versus City of New York in 98 actually ruled that it was unconstitutional for presidents to issue line item vetoes. Congress actually tried to even give President Clinton this authority, which would have allowed him to strike individual portions out of a bill. And that's probably a good thing, because then it just allows the president to kind of dissect legislation and take out all the stuff that they don't want and then just keep all the stuff that they do. The United States versus Nixon in 74 dealt a huge blow to the Nixon administration, and it upheld the judicial review precedent of Madison versus Marbury because, a lot of times Supreme Court cases will overrule previous ones, like with Dobbs, overturning Roe versus Wade. This case upheld the Marbury case from 1803, and it said that the president does not have the ability to define their own privileges. This allowed Nixon to be subpoenaed and forced to release the Watergate tapes, and it led to his eventual resignation. Now, Nixon versus Fitzgerald in 1982 ruled that the president has absolute immunity from civil liability for their official actions, and if that sounds a lot like the case we heard recently, it's because it does. The difference being one is for civil liability, one's for criminal, and the difference being you can be found civilly liable for something and has a lower bar of evidence for you to be held civilly liable. Basically, in legal jargon, not beyond a reasonable doubt, but more likely than not. However, there was a court case in 97 with Clinton versus Jones, and it ruled that the immunity does not apply to non-official acts. So basically, if the president does something that's within their official capacity, any civil liability that they have is not applicable. But if they do something that's not within their purview, then they are not immune from liability. The problem with this, and it's also the same problem you see in Trump versus United States from last year, that rule the president has full immunity from prosecution from official acts, but not from official acts. It fails to define what that means. What are the official acts of the president? Because the Constitution doesn't lay them all out specifically. There are plenty of things a president does, like writing an executive order, that is an official act, but may in and of itself be something illegal. So it's very vague in its language, which is not uncommon for the Supreme Court or for the Constitution in general, and we are almost guaranteed that we're going to have more cases about that in the future. So there we have it, a reasonably comprehensive look at the presidency as established by the Constitution and a handful of Supreme Court cases. I hope this has been an enlightening experience for all of you watching, and ideally put your mind to rest the next time any president makes another harebrained decision and, flies right in the face of logic and reason and legal authority. Stay tuned for the next video, and remember, never stop learning.